has been practised continually through the 19th and 20th centuries. And so the evidence you have is the continuation of tikanga. And that is the point. Now, if I had more time, I really would take you through the examples. Each of them is important in their own right. But the broad point I want to make is that the facts before you are that tikanga have been practised throughout the period that you're looking at, 1840 to the present day. I wanted to make another point, actually, and that is hapu have survived. It's not mentioned in the document. And I guess it's arguably relevant within the issue 14 tikanga submission, but just in terms of social structures, I think it's abundantly clear to the Tribunal that the hapu of ngā puhi as hapu are still here today, and those structures have survived. Now, my learned friend Mr. Hill took the Tribunal through concessions the Crown made in terms of the individualisation of title, for instance. The Crown conceded that that, for instance, had undermined traditional structures, and that is the case, and I'm not taking away from that concession at all. But it is a fact before us that kei konei ngā hapu o ngā puhi. In August 1839, Hobson's instructed to come here, and the instructions include within it statements around assimilation. And despite any such of those statements, the hapu have survived. So those are my submissions in addition to the written submissions. Perhaps if there are any questions on issue 14? On, sorry, either issue 14 generally or tikanga more specifically.
I have a question, Mr. Irwin. You've, under your exercise of kaitiaki-tanga, you've listed a number of claimants discussing how they continue to exercise it, but would you agree there were a number of claimants who also gave evidence as to how it has been so difficult to exercise it, and that the evidence is that they feel that their capacity to do so has been undermined, and what they talk about is the constant struggle they have to be able to express it?
I'd see it in a different way, because the way I see it is people are saying they've continued to practice the practices. And they do make statements along the lines of what you've just said. I think one thing that remains a fact that I have to accept is that decision making has changed. In that ngā hapu o ngā puhi, the hapu of ngā puhi, are not the decision makers, and they were before the treaty. And so in that respect, in terms of tikanga, there's a change, and that's an important change, obviously. And that's a very broad statement I've just made. But the way I've seen it is actually the evidence has shown that people have continued to do what they've wanted to do, with the one caveat perhaps around having that ultimate decision around it. One thing that intrigued me was the role of tohunga in this inquiry district, and throughout the inquiry I was putting questions to claimant witnesses around whether tohunga had in any way been prevented from being tohunga, because of course we have the Tohunga Suppression Act, and I couldn't find one example where we have evidence that that act was applied, for instance, and that a tohunga was stopped from practising as a tohunga. And on the contrary, I only found evidence from claimants that their ancestors continued to practice in that way. So if I can apply that to anything, I can apply that to fisheries. For instance, the evidence is from the claimants that they've continued to access kaimoana, that they participate in the current regime and issue, for example, permits to allow for a customary take of kaimoana. The regime is one of the Crown's, and it's not a regime that I think this tribunal has jurisdiction to question, but my point is that as an overarching point, no, I see it that tikanga is practised by the claimants, and I struggle to find examples where Northern Māori have been prevented from doing so.
Have they been supported, actively supported in doing so?
Well, that's a broad question, and in a way it comes right back to issue one, doesn't it? Depends what we mean by tikanga. If the Crown actively provides in the 1860s for a political structure whereby Ngāpuhi Māori can govern themselves and Ngāpuhi can apply their own tikanga, then the government is actively supporting the practice of tikanga at that time. If throughout the 20th century the Crown does provide certain structures which change over time, where perhaps not with as much lawmaking power, but where Ngāpuhi Māori can apply tikanga, then that is evidence of support of the practice of tikanga. I think there are current day statutory examples where the issue of tikanga is also recognised as well. So again, there's that. And I would also say that there is I guess for a government, things change over time, don't they? When we conceive of what should a 19th century government do for its citizens, for instance, what support should a 19th century government give to the practice of any form of religion by its citizens? And what would we expect of a government in that regard? Would we expect it to actively support the practice of Christianity, for instance, as opposed to any other particular religion? And society's attitudes as to what a government should do vis-a-vis the cultural practice of any of its subjects might change over time, and that's also a relevant consideration.
When we come back to kaitiaki,
yes,
and I was trying to discuss this a little bit with Mr. Melvin yesterday, and it comes back to this point, doesn't it, that, you know, if you look at the looking after the oysters, for example, there is the possibility there's in the Māori Council Act, there is provision there for Māori councils to regulate that fishery.
Yes.
But in the end, the Crown chooses to exercise its powers above that.
Yes.
So it ignores that option and goes back to the kawanatanga option.
Yes, and I think that particular example is a tricky one for the tribunal, because fisheries is expressly mentioned in the treaty in the English text, and there's no question that fisheries are governed by, referred to in the treaty, whether in English or Māori, it's expressly in English, but claims to fisheries are the subject of a settlement in 1992.
well, it depends whether those regulations are to do only with commercial fishing or
non-commercial fishing, and
or whether there's there's kind of an overlap in that particular instance.
Yes, but I also understand the effect of the 92 settlement in terms of non-commercial fishery rights, that they are now codified through the regime that is provided there.
All right. Well,
and the rights continue to give rise to treaty duties on the Crown. Mm-hmm. The Act states that, but the Act also states the Tribunal has no jurisdiction in respect of that settlement.
Anyway, I was really using that as an example that's my head at the moment.
Yeah.
And I just wondered, my last question is there a difficulty about who is defining the meanings of these terms? Because to go outside this into the water inquiry, there's the argument is when it comes to kaitiakitanga, that the interpretation and what the Crown is prepared to support and recognise is a good deal less and a kind of a softer, if you like, interpretation than what Māori think it means and what they would like to see being endorsed, if you like, and supported by the Crown.
Yes, well, I wish to make no comment in regards of course, the water inquiry had nothing to do with that inquiry. But just dealing with this inquiry, I don't understand that has been so much of an issue. The Crown would recognise that tikanga has a very broad meaning, and that when we're talking about it in terms of the submissions and the questions that the Tribunal has posed, and in terms of this inquiry, we look at tikanga in a very broad sense. I would hesitate to give my own meaning to tikanga, because I think the people themselves will have their own attitudes and views towards it. But I would say that we've approached it and I've sought to approach it from a very broad view, because as I tied back to issue 1, and as I think you want to tie back to issue 1 quite relevantly, the exercise of te tino rangatiratanga o rātou whenua includes within it surely the exercise of kaitiakitanga. It includes the exercise of tikanga in respect of these whenua. And that can mean a very broad thing. And what I've sought to show are the numerous examples where I see that has happened and has happened throughout time. It's limited particularly when people sell land, because they divest themselves of the control and the capacity to access land and the ability to practice tikanga in certain locations. And to tie this all together, we come back, of course, to that issue of individualisation of title, because that's the problem, isn't it? In that respect, that if certain individuals are able to alienate what's a group right and responsibility, then that becomes a problem for the application of tikanga. Think of forests. If individuals sell land that are forests, that the group accesses and uses and practice tikanga through the hunting of kukupa, or through the connection to streams, or the exercise of mātauranga through the collection of certain rongoa, the individuals, if they sell that land, have impacted on the ability of the group to practice tikanga, and the Crown has facilitated that in providing the means for the individuals to sell the land in the first place. And we have evidence that where the Crown is in control of these forests, it does try to work with the people to give access and to let them practice their tikanga. And I think we've referred to an example there, the work between the Crown and local Māori, and I think it's the Puketi forest with the release of kokako.
All right, well, thank you. I think we can leave it there. Thank you.
Kia ora, Mr. Irwin. You may think you've answered this question already, in which case tell me. But I was interested on page 100 in your wording of your answer to the Tribunal's specific question, paragraph 279. And you say, in terms of the first question, the Crown does not consider it has a duty towards tikanga per se. I wonder if you could just tell us why that particular wording.
Yes, and I maintain the wording, wouldn't change it. But to explain it, the Crown sees the treaty duty in terms of a treaty duty that is relevant here to actively protect the matters in Article 2 of the treaty, such as, for example, lands in taonga of Northern Māori. And of course it accepts it has a duty to act in good faith, fairly, reasonably and honourably towards Northern Māori, which is also stated there. So the Crown just doesn't conceive of the issue as being as distinct as what I say in the first sentence. The Crown doesn't see there as being a treaty duty as such towards tikanga. Because for one reason, I guess, tikanga is not referred to expressly in the treaty, either English or Māori. But in no way am I shirking from the duties that the Crown has, and through my discussion with Dr. Anderson, the Crown maintains that through the treaty, Māori continue to have te tino rangatiratanga o rātou whenua me o rātou taonga katoa. The Crown has a duty actively to protect that, and therefore that is likely to include the active protection of the exercise of tikanga.
Yes, I wondered. Thank you very much.
No further questions, Mr. Irwin.
Well, thank you, members of the Tribunal. We'll now move to issue 13.
Kia ora. So I'll be presenting the Crown closing submissions for issue 13, and that's document number 3.3.409. So the key theme of these submissions is that the facts show that the Crown has acted reasonably and in good faith to improve the socio-economic status of Northern Māori from 1840 to the present day. At paragraph 4, these submissions will broadly address health, education and housing since 1840 to the present day, and within housing that's particularly the ability to build on multiply owned Māori land. The Crown accepts that the treaty requires the Crown, when it provides social services to the population, to act fairly, reasonably, honourably and in good faith towards Northern Māori. Where the Crown provides social services, it does so as part of its governance role. And where the Crown provides those services, it must ensure that Northern Māori have the same access and standard of social services as citizens of New Zealand. Where disparities exist, the Crown has specifically targeted the social service delivery in an attempt to remove those disparities. The Crown cannot guarantee outcomes. However, it is taking reasonable and treaty-consistent steps to address the disparities that exist. In the Crown Statement of Positioning Concessions, it was acknowledged that land loss has had a significant impact on the social, cultural and economic well-being of Māori across Northland. The Crown maintains that position, but does note that land loss alone has not resulted in the current socio-economic situation Northland Māori are faced with, as socio-economic issues are inherently intertwined and complex. At paragraph 8, the critical issue for the Tribunal is whether the facts show that the Crown has acted and is acting in good faith in all the circumstances in the health, education and housing services it provides in Northland. The Crown submits that the facts show that it has done so and continues to do so. So turning first to address healthcare. At paragraph 9, the main focus of the claimant generic closing submissions on health is the gap between Māori and non-Māori health, with the claimant submitting that the crux of these submissions is that the Crown has failed to do enough to bridge the gap between the health and well-being of Te Raki Māori and non-Māori. Moving to paragraph 18, the Crown acknowledges that a gap in health outcomes between non-Māori and Māori exists today, and the Crown considers this to be unacceptable. The Māori Health Strategy states that the Government and the Ministry of Health have made it a key priority to reduce health inequalities that affect Māori. And the evidence in this inquiry shows that the Crown has specifically targeted Māori health throughout the 20th century to the present day. And while the Crown has some influence through its responsibilities for funding health services, I'm at paragraph 20, and developing health policies, a large number of important influences of health are largely controlled by individuals themselves. At paragraph 22, it is also important to note that the role of the state has evolved considerably over the course of the 19th and 20th centuries, with the Crown becoming increasingly involved in measures to address socio-economic issues, including health. At paragraph 23, the Crown notes that there is little evidence in this inquiry concerning the provision of healthcare in the 19th century. However, at 26, the Crown submits that throughout the 20th century, the available statistical and other evidence shows that the Crown specifically attempted, in good faith, to improve the health position of Northland Māori. The New Zealand Department of Health came into existence in 1900. The Public Health Act also made specific provision for Māori health. At 28, the Crown lists some examples of measures taken by the Crown over the 20th century to improve Māori health, as well as Northland Māori health, and I'll just take you through a few examples of those. So at 28.1, there were state subsidies for primary medical care introduced in the first decade of the 20th century, and in the first instance there was to be attendance on Māori and back block settlers. At 28.2, some primary medical and nursing care was delivered through the Native School Service. At 28.3, a 1928 return indicated that there were 3 Māori health nurses situated in the Northland Inquiry District. And by June 1938, 6 district nurses were stationed within the Northland Inquiry District at Rawane, Kawakawa, Whangarei, Broadwood, Kaiako and Kaikohe. And by 1945, there were 21 district health nurses working in Northland, and of these 21, 15 worked within the Northland Inquiry District. At 28.6, the rate of incidence and the death rate from typhoid declined steadily from about 1920s onwards. Crown actions at paragraph 30 need to be assessed in relation to the time that they occurred and the prevailing circumstances of that time. And Dr. Hearn accepted in cross-examination that the Great Depression had a significant influence impact on the Crown's finances, as did the two world wars, and this affected the ability of the Crown to deliver social circumstances. But he did agree during cross-examination that the Health Department's response was commendable during this period. At paragraph 32, the Crown offered mass vaccination programs through the District Nursing Service, and Dr. Hearn states that during 1912 the Department of Health conducted a rigorous campaign to eliminate recurrent epidemics. In the 10 years between 1926 and 36, at paragraph 36, the national Māori population increased by 29%, and in the inquiry district there was a similar trend. And in 1944, 5,019 inoculations were conducted, and 5,324 were conducted in 1945. Dr. Hearn also gave evidence that Northern Māori were predominantly rural, and the Tribunal has stated in the Whanganui Land Report that they accepted that people living in rural areas will never enjoy the same access to healthcare as city dwellers, going on to state that there can be legitimate disagreement over the level of service which the Crown should provide, but it is entitled to concentrate its health funding in large centres of population where it will be most effective. The Crown would submit that while that's so, there is evidence to show that the Crown has focused on delivering the services to Northern Māori, despite their location being particularly rural. And at paragraph 40, Mr. Wolsel agreed that life expectancy at birth is a widely used measure of a population's health, and he agreed that there had been an improvement in life expectancy at birth for Māori and Northern Māori between the periods of 1901 to 1926, 1926 to 1936, 1936 to 1946, and 1946 to 1951. So, as the Tribunal will be aware from the Crown evidence, I'm now at paragraph 46, New Zealand has a devolved health system. This means that we have roles and responsibilities split between the Ministry of Health and district health boards. The Ministry of Health sets the policies and objectives, and the 20 district health boards are the operational components within their respective regions. At 47, Dr. Nick Chamberlain from the Northern DHB, agreeing with Claimant Counsel in cross-examination, confirmed that the broad policy rationale behind this devolution is to get work into the communities to enable community involvement. And the New Zealand Public Health and Disability Act is explicit about Māori being involved in decision-making and in service delivery, and reproduced at paragraph 48 is section 23, which has those provisions. And at 49, in the Tribunal's Napier Hospital and Health Services report, the Tribunal stated that the explicit provisions in the Public Health and Disability Act 2000 for ensuring proportional Māori representation on district health boards and standing committees are fully consistent with the principle of partnership. The New Zealand Health Strategy was refreshed in 2016, and this sets the framework for the health system to achieve the overall goal that all New Zealanders live well, stay well and get well. And Ministry of Health witnesses confirmed that when developing this strategy, 11 Māori-focused hui took place across the country, with one here in Waitangi. The Māori Health Strategy supports the New Zealand Health Strategy, and this was originally published in 2002, and it's been updated with input across the health sector in both 2013 and 2014. And the Māori Health Strategy contained explicit references to involving hapu to ensure there is engagement where appropriate and to have increased Māori participation across the whole of the health system. And again, the Ministry of Health witnesses confirmed